Good afternoon, everybody. I said I wouldn't make videos unless I thought it was really important or I had something important to share. And first off, probably the most important thing I want to share is Ron Lyons needs y'all's prayer. He's sick. He's bad sick. And I don't mean like COVID or the flu or anything like that. So y'all be praying for Ron. Ron's instrumental. And he is, I would consider, one of my gurus. The first, matter of fact, probably the one that I befriended personally. Ron is super crazy intelligent with this stuff. He's been doing it for quite some time. And he's sick. He's bad sick. I don't know what the problem is with the VA, but I'm very unpleased with them right now. But here's what's going on. I'm not going to hold up my YouTube channel's address or anything like that because I don't really care if the scammers grab this and put this on their YouTube channel. Wednesday in Nashville, Wednesday the 12th. We're going live. If you go on the YouTube channel that's listed right here, Tenn Courts, right? And go to the live stream or go to videos and then go to live stream, you'll see this. If you'll notice, there's one notification there already. That's mine. You can go there and set the notification to notify you when this is going to happen. And there are 5 cases on the docket that day for this. And we are the last one. It's saying right here 1 o'clock. But it'll probably be more like around 2. Because we're the last ones. And like I say, y'all, they like to put me last. They don't want an audience to hear what's going on. And I'll hold that up once again for this video is over. What this is, I've been talking about it somewhat. And what this is it's me arguing. If y'all have seen the Court of Criminal Appeals video on our case for the first appeal, and then you remember the Supreme Court, I know 50,000 of you all, or at least 40,000 of y'all, have watched those videos. 40,000. It's the most watched YouTube video on Tenn Courts. More than chick who killed her 2 babies. So it's watched a lot, and it was due to my channel being up. And this time I'm arguing. This has to do with post-conviction relief. Now, in the past, this post-conviction came about because we filed for post-conviction, and I filed et al. Or edit all. And we filed on the 9th of May, and we had till the 15th of May to have it in within a year. A year after the Supreme Court's decision came down, we had a year to file post-conviction relief. We took our time with it because we wanted to be completely thorough, and we set it in on the 9th. Well, we sent 3 copies that same day out of Newport. We sent one to Jonathan Skermetti, who is the Attorney General of the state of Tennessee. We also sent one to Blackburn, and then we sent one to the clerk. Skermetti they all got to Nashville. We sent them out on the 9th. All 3 of them went certified mail return receipt. and they went to Nashville. They were all in Nashville by the 10th. Skirmetti got his on the 13th. Blackburn got hers on the 14th. And for some reason or another, the clerk didn't get the copy we sent the clerk. And when it was returned, this is what I printed off right after that. And if you'll notice, this is the United States Postal Service tracking information. And on there, it says May 15th, moved to the next facility in transit, arriving late May 15th, which would have been on time. They arrived in Nashville May the 10th, right? And it says it'd be on time. This is April the 1st of 25, and it was showing that it's still moving in transit. So they're showing that it never even got there to the clerk. And we sent it to Joseph P. Day. This is a photocopy of the green card that we sent. And if you notice the date here, right? That's been modified from the 15th to the 16th. There is a United States Postal Service investigation, Office of Inspector General investigation, still going on. I don't know why we'll contact you whenever our investigation's over. Still haven't heard from them. Probably won't. But she said we were a day late. And we had a colorable claim, but we were a day late. So they denied the post-conviction relief hearing. She did this. She said we were a day late. She was 9 months late reviewing the post-conviction relief. And, even though you guys are a day late, even though I'm 9 months late, I'm not going to listen to it because you're a day late. But she said that Lee Cromwell filed he filed a timely filing. So our argument is even if there wasn't some shenanigans going on with the postal stuff, you can't sever us. Severance only happens in pretrial. Once you sever, first off, the defendant has to ask for severance. They have to file a severance for severance, and then the judge grants it or not. In our case, they didn't, because there were 25 witnesses, and a lot of those witnesses would have had to showed up at all 5 of our individual trials if they had severed. So for convenience, they didn't sever us. Well, now they're trying to say that Lee Cromwell's was a timely filing. And I hadn't had a chance to look at it yet either. As far as we know, we can't get in contact with Lee. I don't know. He's in the wind or whatever, but I wished I could. Lee, if you're watching this, contact me. Get a hold of Michael or Ron or whoever. But that's the argument, and there's a lot more to it, y'all. I'm going to be arguing this in the appeals court. I'm not an officer of the court. You're not going to push me around like you can your cronies, your little pawns, your little attorney lawyer pawns. I'm going to go in there and I'm going to say what I got to say. And believe me, folks, I'm unloading in a nice way. But one thing that needs to be understood is the appellate court or the appellate tribunal. And if you'll notice, there'll be 3 justices. That's a tribunal. Three. uh, just like a court martial, when you go into a court martial in the military, there's three officers. They don't necessarily have to be judges in the military, but there'll be three of them in there. And we did a judicial notice, a motion to take judicial notice, and they accepted it. In the motion to take judicial notice, uh, we put in, and the thing about it is, in a judicial notice, when you file a judicial notice, they have to accept it. There's no, well, we can or we won't. They have to. And if you'll notice, this is one of them's oath of office. All five of them, the three justices, the clerk, and the lady arguing for the state, found all their oaths of office, and we filed it in. We told them to take judicial notice, but we weren't sure whether they would file them or not, so we did. Now their oaths of office are in there. If they violate the Constitution at all, they lose their qualified immunity, and we will own them. They also noticed the United States Constitution, and they also noticed the Constitution of Tennessee, which says, Article 1, Section 1 says, all power is inherent in the people. All free governments are founded on their authority, and for their peace, safety, and happiness, they have at all times an unalienable, an indefeasible and unalienable right to alter, reform, or the government in any manner they think proper. What does that mean? That means we're sovereign. We the people are sovereign. That's what Article 1, Section 1, the very first thing of the Tennessee Constitution says. And a lot of y'all have the same stuff. You guys' constitutions are a lot of the same as ours. Because we're older. We're the 16th state. A lot of states ripped off stuff from ours. I might have worded it different, but it's all there. And then Article 1, Section 31 of the Tennessee Constitution is a description of the boundaries, the eastern boundary of the state of Tennessee. It's seceded. Tennessee seceded from North Carolina. That's how Tennessee became a state. And they use geographical landmarks to describe the eastern boundary. The western boundary is described as the Mississippi River. And then the parallels are north and south. But the eastern side of the state was mountains. If you read it, you'll notice that Paint Rock is one of them. Paint Rock is one of the locations of the eastern boundary of Tennessee. That was the rock that I fell 50 feet off of in 92, shattered both my ankles. But anyway, in there it says, after it gives a description, it says, over which the people have the right to exercise sovereignty and the right of soil. That's why we have Admiralty Maritime Law of the Sea on the land now. And I thought I'd just share it, but in there it says the people have the right to exercise sovereignty. We are the people. So they've recognized that. They've recognized me as a sovereign, me and my other guys, as sovereign. And that's some of the issues that we put in there to take judicial notice. We did an amendment to take judicial notice, and we added Snydash, the Supreme Court ruling in 1969, Snydash versus Families Finance Corporation. And in there it says that we the people, or there's basically, in a nutshell, it says we don't need legal basis to lien somebody. You can lien a man, depriving him of the beneficial use of his property without any legal determination or probable cause. This dates back to medieval England and even back to Roman times. That's a Supreme Court ruling. And in there it says you don't need legal basis. You don't need legal permission to lien somebody. Although we never liened anybody. What we did is we gave the lien securities to the Treasury, and the Treasury liened them. Everybody out here likes to think, well, I'm going to look him up and see what he did. Oh, he liened all these public officials, judges and shit. No, I didn't. I can prove that. But there's going to be some interesting arguments in this. And I wanted to share it because I would like for y'all to blow this video up. Okay, here it is again. You know, I don't have a lot of subscribers on my channel, but the scammers do. The scammers do. So go ahead and take this scammer and put it on yours. Put it on your act like you're me. But like I always say, people, don't give anybody any money. I won't ask for it. Don't ever. If someone's claiming to be me and asking you for money, it's not me. It's somebody else trying to take your money. So that's going on. And I'm arguing it. So, and it's going to be eventful and it's going to be fun. I'm going to enjoy this because what people don't realize, including these justices, they've never heard what this lower court did. If you watch Emma Tenn arguing and this Bruce guy or Russ, whatever his name is, arguing the appeals and in the Supreme Court, they're not telling you that they're not that they're not our lawyers. They're not telling those justices, Mr. Hauser's not my client. Matter of fact, they're lying about it. They're lying about it. And they haven't heard this. It hasn't gone up any higher than Division 3. And Blackburn's crusty old ass is retired. So it's not going around. It's not being heard. The media is sure not out here freaking, hey man, these guys got screwed by our government. So if you can, get on there and watch it live. Or if you can't, watch it later that day. Like and comment. Blow this up. I guarantee you it's going to be... I only get to talk for 20 minutes. So it's not going to be a long, drawn-out thing. It might be 5 minutes of the judges walking in and sitting down and my introduction. Listen to my introduction, y'all. Okay? If you don't listen to anything else I say, listen to the introduction. How I introduce myself. Devote it to memory. It's going to be crazy. Share it with your friends. Telegram. I'm going to share this one on Telegram. I'm a little more active in that now. So, and my admins are freaking awesome. I was on a live a couple of nights ago with Joe and Bree and their sovereign group, their trust group, and that was pretty fun. I enjoyed that. But this has consumed a massive amount of my life over the last going on 9 years now, y'all. And these judges are going to find out that we were never shown warrants. They're going to find out that we were never given an indictment. Oh, and by the way, the indictments, when I did finally see them, I was out on parole. And in Emma Tennant's office is where I finally seen the indictment. And in the indictment, it's not signed. It's not signed by any clerk or the grand jury or anything. It's somebody's initials, KT or something like that, whoever in the hell that is. And the Constitution of the state of Tennessee, Article 6, Section 12, says that they have to be signed by the clerk. Stamped, filed, and signed by the clerk. Or they're void. Our judgment sheets, all 42 of them, none of them were stamped, signed, and filed by the clerk. They had a year to make that correction. They never did. Our judgment's actually void. I'll argue some of that too. So there was an alleged arraignment where I was never told the nature and cause. We never talked to attorneys. I never talked to an attorney. You have the right to counsel. If you can't afford one, one will be appointed to you. Never talked to one. There was a trial that we weren't allowed to go into. We never seen a jury. Never testified on our own behalf. Never questioned the witnesses. This is 4th, 5th, 6th, 7th, 8th, and 9th Amendment violations of the Constitution. It's due process out the freaking window. So they're going to hear this. And I would like to see an outcome of right rule finally after freaking almost 9 years. I would like to see the outcome of right rule. I really would. And we're giving Tennessee the opportunity to do such. Now, but ultimately, I don't freaking care. Because you want to choose to keep this charade going on, that's fine with me. Because our next step is going to the federal courts. We're going to file a 1983, you all, as deprivation of rights under color of law. It might take a little time to get through this, but the feds are this is going to the Fed. Unless Tennessee rights this egregious wrong and makes some kind of retribution, at least some kind of offer, hey, we screwed you guys bad, man. What will it take to settle? What can we settle for? They're going to have to do something like that. If they don't, this is going to the federal courts, and it'll be heard in the federal court. It will. How do I know this? Because my ex-wife had it discharged in bankruptcy. $4 million discharged in bankruptcy. How do you do that? How do you discharge something like that? Here's the kicker. Title 11, United States Code, Section 536 or 533, subsection A2. It says, of the section will bar discharge only where bankruptcy has actual, or only where bankrupt has actual knowledge of falsity of a statement or reckless disregard for the truth. My ex-wife swore under oath she had no contract with me. That was in the spring of 2018. In the winter in December of 2018, she had actual knowledge of falsity when she said when she testified she had no debt with me, and then took the $4 million debt into bankruptcy. A bankrupt is discharged from provable debt if they are properly scheduled. I just showed you the backside of the properly scheduled. She scheduled this in debt and discharged it through bankruptcy. The only way you can do that is to show the contract, the same contract that the court decided to hide in the record and not show the jury. There is, in the transcripts, when they released the jury, Okay, go home for the weekend. Come back and we'll have closing arguments, and you guys can go back and decide whether or not these guys are guilty. Okay, guys, now that they're gone, let's talk about this. Let's talk about this contract that these guys have, but we're not going to let the jury know about it. And the people that had the UCC ones removed, the public officials, my ex-wife couldn't do it because she wasn't a public official. These people had these UCC ones removed via an ex post facto law. We had these on them before the state created this new law that if you do a UCC one on a public official, they can have it removed. Well, they had to sign a sworn affidavit saying they had, that this debt wasn't theirs. But most of them said, I got something in the mail. I got a packet in the mail. This guy sent me something. And then they turned around the very next year and went into the courtroom and said, I don't have a debt with this guy. That's aggravated perjury. Tim Burchett, United States Congressman from Tennessee, said this same shit. Yeah. You sign an affidavit saying you had no contract, yet you got something in the mail from me and just gave it to your attorneys. Okay, let's hide the contract inside the record for ID only. They also put for ID only the affidavits that all these public officials signed. They wouldn't let the jury see those. So, yeah, folks, this is going down, man. Yeah, I'm probably going to leave tomorrow. Tomorrow's Veterans Day. And instead of having the big cookout here like we do every year, I'm going to be driving to Nashville. So I can be there. I want to be rested and get up early enough to. I could leave Wednesday morning because they're not going to do this till, well, it says right here they're not going to do it till 1 in the afternoon, 1 p.m. Nashville time. So I could drive down early in the morning, drive, not too early, but decently early. No, I got to be there at 9 o'clock when they call the roster. So, yeah, we'll do it. I've missed out on a lot of things going through all this, but, man, for freedom, for liberty, for peace, safety, and happiness, you wouldn't believe what I'll go through. I will sure do it. Y'all, I'll get this out as soon as I can. As many as y'all can. If you can do this live stream, check it out. Come back and hit me up with messages or whatever. But share this like crazy. It's gonna be eventful, man. And other than that, y'all have a blessed day. It's good to get back on here. Love you, bye.